Okay, the topic today is with regards to relation between partners and outsiders. We are going to look at as to whether what is being done by the partners when they enter into a contract, whether it can actually bind the other partners and whether they can actually bind the firm. So there are certain transactions which is done by the partners, it will actually bind the firm. Okay. So we are going to look what kind of transaction which is done by a partner which can actually bind the firm. So we know that partners are agents of the partnership. This is settled so under Section 7 of the Partnership Act. And because of that, the principles of law of agency under Part 10 of the Contract Act of 1950 and the English law of equity will actually apply. So, okay, the partner's power to bind the partnership depends whether they have this actual authority, usual or apparent authority. The authority of this partner, if this is actual authority, it can either be expressed or implied authority. So most of the time, express authority is being in writing, though it can actually be done orally. Whereas apparent or noticeable authority, this is an authority which can be seen from the from the types of business. You can see, okay, this is the normal powers that the partners have. This apparent authority, as I told you earlier just now, it can be given in writing or can be done orally. So in writing it's very easy because it is inside the partnership agreement. So implied authority can be inferred from the conduct of the said parties. So apparent or associable authority, this occurs when the partner holds out to others actually that they actually have the said authority. So let us go on with the usual or apparent authority first. So these are the authority or power that a partner normally has when they wanted to carry out the said act for the purpose of the partnership business. So these are the situation whereby a partner does this act. Normally the other partners which did the same kind of business like him will have the said authority. So let's say this is a legal firm. So a lawyers normally they have the authority to go to the court, to sign document, to entertain client. This is the usual or apparent authority which we can see that the partners of a legal firm possess. And under Section 7, it said every partner is actually an agent of the firm and his other partners for the purpose of the business of the partnership. If what he did is actually in the usual way of business of the kind carried on by the firm of which he is a member, and if this is the situation, it will actually bind the firm. So we can see I have underlined the word usual way of business of that kind carried on by the firm. It will actually bind the firm unless these partners have no authority and the person who the outsiders actually who enter into transaction he knows that he does not have authority, then the firm will not be bounded by his action. So from this section 7, I have listed down these actually 4 conditions which need to be fulfilled before we say whether what is done by the partner will actually bind the firm or not. So these 4 conditions, number 1, whether what is being done by the partner is really within the scope of the partnership business. Secondly, whether it's been carried in the usual way. Thirdly, whether the third party who entered into the transaction knows or believes that actually this person actually is a partner of the firm. And number 4, the third party also must not know actually that this person who entered into that transaction has no authority or permission of the firm to act on behalf of the firm. So let us discuss this one by one in detail. So number 1, what is being done by the partners must be within the scope of the partnership business. This means that what he did must be related to the type of business which is being carried out by the said firm. So let us do a comparison between these 2 cases. The case of Mercantile Credit Company Limited versus Garrett and the case of Higgins versus Become. So in the case of Mercantile Credit, the firm was found liable for a deal involving a motor vehicle which is being entered into by another partner, and actually what he did is in contravention of the partnership agreement. So why actually the court held that the firm is liable? because the court held this is liable because this is a motor garage companies and dealings in motor vehicle was usually usual, meaning it is related to this type of business. Whereas in the case of Higgins versus Bichamp, the decision is contrary to the decision of the case of Garrett. Because in this case, the court held actually the firm is not liable for the debt owned to a third party, whereby this debt is being affected by one of the partner, and this also contravene the partnership agreement. In the case of Garrett, also it contravene the partnership agreement. The difference here is that this is the business of a cinema, and because the court held this is not a trading business, and what is being done by by this partner actually is not something which is related to the type of a cinema business. So that's why in the case of the term, the court held actually the firm is not liable. So let us have a look in the Malaysian case of Chang Kin Yu versus Lee and Wong. So in this case, what the husband did, the husband borrowed 35,000 ringgit from the wife. Why he borrowed money from the wife? In fact, he gave receipt to his wife. So he borrowed this money from the wife because this money was later on used to pay off the debts of the partnership. And later on, the wife brought an action to recover the loan because the said loan was not paid by the firm. Court held actually this borrowing was an act necessary for the carrying on of the said business of the partnership. And because of that, the rest of the partners is being bound by the said transaction. So this is something which is necessary. So meaning, if the said business did not borrow money from the wife, they still need to borrow money from other creditors because the money was used to pay off the debts of the partnership, and it was not being used for something which is not related or something which is not relevant to the business. So meaning the money was used for something which is related to the said business. So number two, it is carried on in the usual way. So if something which is usual, this is not good enough to put liability on the firm because something is usual, however it's not ordinary, then it will not actually bind the firm. So that thing must be usual, that transaction must be something which is usual and ordinary. Okay, so to understand this more clearer, let us have a look at the case of Goldbing versus Jenkins. So in this case, one of the partner borrowed money on behalf of the firm. However, he borrowed money at an exorbitant rate of interest. Dia pinjam duit pada kadar faedah yang melampau, terlalu tinggi. The court held actually, borrowing money is actually something which is normal, which is something which is usual. But this is not within the ordinary course of business. Because if we borrow money, of course, we will try our best to find the best interest. Okay? The best interest rate. So in this case, what the partner did, he borrowed money, however, the rate of interest is very, very high. So actually, this does not make sense. Okay, number three, the third party must know or believe the person with whom he enters into the transaction or contract is a partner. So if this third party, when he entered into the transaction, he assumed, he believed that actually this fellow have the authority to bind the firm. Then under that situation alone, the said firm will be held liable. So to understand this situation further, let us have a look at the case of Sitambaram Chetty versus Hong Hing and others. So in this case, the partners have never revealed actually who is actually the partners of the said business. This is a business of selling liquor because all the time, all transaction is being done by the managers, and in fact, the managers is the one who runs the said business. And because of that, to the people who conduct transaction with this business, they thought that this manager are actually the partners of the said business. And then one of the manager, they borrowed money and then he absconded, he disappeared. And now plaintiff is suing the real partners. Court held the partners were held liable because why? Because all the time to an outsiders, they thought actually these managers are actually the partners of the firm, or maybe they thought that he have the power to bind the said firm. So in this case of William Jack versus Chan Yong Trading Company, So this case I have highlighted to you earlier. Okay, in fact, now we are going to refer to this case again, whereby this case involved an infant partner, whereby this adult partner introduced him as the partner of the firm. And this infant partner, this is a minor, he ordered goods, however, later on, he fails to pay for the said goods. And the adult partner was made liable to pay the said goods because he is the one who made other people believe actually that the minor is actually his partner. And number 4, the third party must not know the person with whom he has entered into the transaction or contract has no authority or permission to enter into the contract. So meaning outsiders do not know actually this person does not have the authority. If the person knows actually this person does not have authority, of course the firm will not be held liable. But under this situation, he does not know. So actually the case of Sultan Baram Chetty and the case of Garrett can be used here. So in Sultan Baram Chetty, the outsiders did not know actually that actually the managers does not have the authority. And the case of Garrett also, the outsiders did not know actually that in the agreement actually this kind of dealing is not allowed. And that's why the firm is being bounded by the state transaction. Okay, so now let us have a look on the actual authority. This actual authority actually, it covers express actual authority and also implied actual authority. What is actually express actual authority? This is actually an authority given to a partner to do an act or execute a function in the firm's name. So meaning it is written, or maybe it is stated somewhere that this can be done by the said partner. Like myself, my express actual authority is inside my agreement with UiTM. Okay, so every semester I will be given the loading and the timetable. This is an express authority. I have to teach this class and that class. Okay. So the implied actual authority, this actually the authority exercised by a person who has been given. I have been given the actual authority. However, to enable me to carry out my task smoothly, I have this implied actual authority. What is my implied actual authority? I can conduct online tests. I can conduct online classes. I can use whatever kind of medium. It have never been stated in any of my agreement, but I have the power to do so. So this is known as the implied actual authority. So I give an example here. So it is an express authority for a salesman to sell car. And what is his implied actual authority? It can allow potential buyers to test drive the said car. Okay. So this is a liability of firm on action of a non-partner. So this is covered by Section 8 of the Partnership Act. So under this situation, whatever action or whatever instrument which is related to the business and is being executed under the names of the said business of the said firm, showing intention to bind the firm by any other person. So meaning it's not done by the partners, it's done by somebody else. So maybe it's done by the clerk or by the accounts department in that firm. So whether the firm will be liable because this is not an action by the partner. So under this situation, okay, the firm will be liable if it relates to the said business and this person is being authorized to do it. However, if you see I have highlighted in red there, this is an exception. So under this exception, it says, provided that this section shall not affect any general rule of law relating to the execution of deeds or negotiable instrument. So meaning, let's say this is a check. Check cannot be executed, cannot be signed by a non-partners. Okay, by the clerk cannot. This is not allowed. Execution of deeds. This is signing of a transfer of piece of land. Okay, so this is not allowed. This also must be done by partners. However, any other transaction can actually. Okay, so meaning is being delegated to this person. This person is not a partner in the firm. However, he is being delegated. If this is a big firm, of course they have clerks, they have manager working in the said firm, and they did something on behalf of the firm. Since they are being given authorization, so what they did, their action or the instrument which they signed on behalf of the said business, that is actually valid. Okay, to look at section A more clearer, so let us have a look at this case of Rebrings and Company, whereby this case involves two partners, and these two partners, they are actually father and son. The firm was in debt, but the firm does not have money to pay the said debts. So what the son did, the son agreed actually to assign the book debts to the creditors. So macam gadaikan buku hutang lah, ya. So buku hutang meaning this book debts actually there is the list of this customer of the firm who actually owes the said firm. Ini senarai buku di mana customer yang berhutang dengan firm dia. Okay. So now he signed, dia menyerahkan hak to the creditors, so that the creditor will give him time to pay the said loan. So what happened is that this son never informed the father of what he did, that he entered into this assignment. So he forged his father's signature. So later on, his firm became bankrupt. And now the trustee was not happy with regards to this, and they wanted to set aside the said deed of assignment because he said it had been executed only by one partner because the signature of the fathers had been forged. However, what the court held, actually this deed of assignment was binding because it was actually an instrument relating to the business of the firm. Okay, so it relates to the business of the firm and is being executed in a manner showing intention to buy the firm and executed by a person who was authorized to do so. You remember under section 8 just now? Okay, so this instrument, it will have to be related to the business of the firm, okay, and that person is being given authorization. So in this case, the son is being given the authorization. In fact, without the signature of the father, still he have the power to sign the said deed of assignment. So that's why it is valid. So now let us go through the liability of firm on a non-related business. So just now, section 8, we look at the situation when actually what is being done is related to the business and is being done by person who is being given authorization. That person no need to be a partner of the firm. Can be somebody else who actually is acting on the behalf of the firm. So meaning the firm can delegate the said task to somebody else as long as related to the firm, then the firm will be held liable. So however, under section 9, this is an action which is not related to the firm business, nothing to do with the firm. Okay, then under this section, if we go through section 9, it says here, where a partner pledges the credit of the firm for a purpose apparently not connected. So meaning the words here is a partner. So it need to be done by a partner. So person who is not a partner, like the case of section 8, cannot do this. So if this is not related, not connected to the business of the firm will still be bound. Okay. However, this person must be given special authorization. Then only the firm will be bound. However, it does not affect any personal liability incurred by an individual partner. Yes, the firm will be bound, though this have nothing to do, not connected with the ordinary business of the firm. However, anything which have to do with personal liability, so let's say what is the transaction which is being entered by the partner is actually his personal transaction. Let's say he entered into an agreement to buy an expensive car. He wanted to make use of the said car. Then under that situation, the firm cannot be held liable because this is a personal liability. Okay, what about restriction on partners? Restriction on partners, so meaning maybe one of the partners does not have the usual partners as other partners have. Why? Because in the agreement there is restriction imposed on him. So let us have a look at section 10 of the Partnership Act, where it says that, so if it had been agreed between the partners that any restriction shall be placed on the power of any one or more of them to bind the firm, no act done in contravention of the agreement is binding on the firm with respect to person having notice. What does it mean by the word persons having notice? So meaning, if this partner actually does not have power to conduct certain transaction, however he did it, will the firm be liable? The firm will be held liable if actually that outsider is not aware that he does not have power. Okay? the firm will be held liable. However, if that person knows actually that this partner does not have that power because of this restriction, then the firm will not be held liable. Okay? So in the case of garage, you can remember the case of garage. In the case of garage, okay, in that case, that partner does not have power to conduct that kind of transaction because the agreement don't allow him to do it. But why actually the court held the firm is liable? Because the third party is not aware of this agreement. So that's why I say here, if the outsiders is not aware, they does not have notice of the restriction, then of course the firm will be held liable. So meaning the outsiders now can actually sue the said firm. So okay, thank you, student.